so as I mentioned, we've done a couple of the previous seminars, so it's been on all the landlord tenant basics, and we would recommend that you go ahead and view that if you didn't watch it before. It is on our websites, or if you can't find it, feel free to contact us and we can send you a link. So let's go ahead and get started. I want to start today, and our seminar focus today is going to be on the actual eviction process. Previously, we were talking to a lot of things that led up to it, but now we want to go over the nuts and bolts of how do you actually evict the tenant, and when you're doing the eviction process, or as it's legally known as the unlawful detainer action, what steps do you need to win your case? And so we're going to go through that specifically. The first thing, obviously, for any unlawful detainer is that you're going to have a cause to evict the tenants. Those causes primarily break down into three categories that we've listed. The first one is the most obvious one and the most common one, which is if they fail to pay rent. So that's relatively clear. That's pretty much the majority of all cases that come up. Tenant doesn't pay you rent on time, and you're trying to evict them because they failed to make payments. There are a little bit more details that we'll go into, or if you have specific questions about, like late charges, or sometimes you may have other fees associated with it, but we're going to focus today largely on the actual rent payments. The second one that we're going to have, and it's going to be much more difficult to prove, is a breach of contract. Now, all the leases have terms that are specific to your property, but most of them include ones that, such as you can't use the property for illegal purposes. You may have other specific house rules or other issues, but the biggest ones that we see especially are going to be the illegal use of the property. That comes up in multiple areas. For example, people have been growing marijuana or other drugs that may be illegal in your jurisdiction, and that may cause some problems. Another problem is that the tenants may be using the property for Airbnb or some other short-term rentals that may be prohibited. And then, that's kind of comes up as a big issue. Typically, there may be other smaller ones like noise violations if they're having loud parties and you're in a multi-family unit where they may be disruptive of other members, or if they're smoking, and that may be a violation of the HOA CC&Rs or with your own house rules. Or you may have pets. Now, please note, this is not service animals, but they may be actual pets that may not be permitted in your lease. In addition, the other big one that we see is that there may be illegal occupants. So you may have a certain amount of people on the lease, and those people, say it's the husband and wife, they start adding brothers and sisters or friends or whatever, and that may exceed the occupant limits that you've allowed. And so if you have these illegal occupants, that may be a breach of the contract and breach of the leasing grounds for termination. Finally, there's the other category, which is a little bit broad, but typically it's because the lease has ended for a variety of reasons. One of the most common reason is that it's going to expire. So if you have a 1-year lease that expires, then the lease is over and you have cause to evict the tenant. Other examples of this would be if there was a fire and there's not otherwise addressed, and the lease may terminate depending on your specific situation. As I said, the most common one of these issues will be the expiration of the lease, and that gives you ground to evict the tenants without having to give further notice, as long as you don't accept rent. So those are kind of the basics of what causes that you have to evict a tenant. The question is that how do you determine this, especially in the cases of a breach of contract? Obviously, with a failure to pay rent, you didn't get the rent check. But if you have other issues like Airbnb, drug use, smoking, whatever, that's a little bit more difficult. California law provides that you have a very limited right of entry into the property. Essentially, the tenant who rents the property has a right to privacy and right basically not to be disturbed. And so you have various exceptions to that, largely sometimes for showing the property for sale. But typically, you can't just go in just to say, hey, I think you're violating the lease. I just want to make sure that everything is done correctly. That's not permitted. But there are other ways to kind of go ahead and deal with this. Namely, especially if you're in a multi-family unit, it's relatively useful if you can talk to their neighbors who may see the tenants more regularly and may be willing to tell. Especially if the violations are along the lines of you're seeing some issues. You may see some issues in terms of that they're having noise disruption, or if they're smoking, or if they have loud or obnoxious dogs. And so that may come up. Another issue that, and so we would suggest that if you have a multifamily unit and your neighbors are friends with you, they may be willing to talk to you. Very rarely do you see any of them willing to provide a statement or willing to testify in court, but at least they'll notify you of the violations. And then the other ones that are a little bit more specific in terms of actually willing to testify or provide you reports are going to be either code enforcement officers or police reports. So if what the tenant is doing is a violation of the law, you may get a police report, or the county or the city may have an agency come in and say there's a violation. Typically, we see this for drug use or some other concerns there. Now, when you have cause and you've discovered that there's these issues with a property, you can go ahead and begin the eviction process itself. But please know, everything, as Lisa say in this entire slide, is that you're not allowed to self-help. This means you cannot just change the locks because they're violating the law. That's not permitted. You cannot turn off the utilities to try to get them out. That's not permitted. California essentially wanted to stop the violence and the other issues that came up with people who were trying to self-help, and had said that the landlord, even if there's a violation of the lease, has to go through the court system to get possession of the property back. So we cannot stress this enough. Do not self-help. Do not turn off utilities. Do not try to get the tenant out yourself. Don't change the locks. What you need to do is go through what the legal process, which is going to be our next step. The start of it is going to be, you need to determine what notices you need to give. So in certain circumstances, no notice is required. For example, if, as we've said in the past seminars, if the lease expires on its own terms, you're not required to give notice because the lease already says it's expiring. So in our typical way, say it starts January 1st, ends on December 31st. As of January 1st of 2018, you don't need to give notice, say, hey, you need to get out because the lease already expired on December 31st. However, in actual violations of the lease, you do have to give notice. They come in multiple different forms. The first one and the most common one is your 3-day notice to perform or quit. Typically, the one most commonly heard is going to be to pay rent or quit, but that's really just one of the covenants. And so when you do this 3-day notice, you need to give it to the tenant and say, here's the notice. You have 3 days to cure this defect. Specifically, the defect that we think that you have on the lease is that you failed to pay June's rent. Now, if you're doing a 3-day notice to quit, it's very important to know that you can only put in the rent on there. There are some very limited additional items you can put on, and we're not going to be able to go over them today, but you basically cannot add late charges or other fees, but you can put in the rents, and you can eventually collect those fees, but you can't put that onto that 3-day notice. So put the 3-day notice, make sure that it's done correctly, and say, here it is. Our monthly rent was $3,000. You've missed the June rent, and so you're $3,000 behind. Pay within 3 days. In some circumstances, some of the violations are drastic enough that you can have a 3-day notice to quit without any right to cure. And those are very extreme circumstances that don't come up all that commonly. Typically, we suggest having a right to cure because it makes it more simpler in the litigation itself. But if there are some extreme circumstances, I think typically involving around drug use, that may come up. Now, as we were mentioning earlier, if you just want to terminate because, and as we mentioned in previous seminars, if you just want to terminate because for no cause, you just want to terminate because you just want them out, what you can do is give them a 30 or 60-day notice of termination. Basically, this means the lease is on a month-to-month process, and that's the only time you can do it. You cannot do it on a fixed-term lease. But if you have a month-to-month lease, depending if they've been there for less than a year, you can give them 30-day notice of termination of the lease. If they've been there for more than a year, you can give them a 60-day notice of termination of the lease. Once the notice has been sent and once the notice has expired, and it's important to make sure that the notice has actually gone, and so you've done the calculations correctly on the time, then you can file your lawsuit. So basically, when you file the lawsuit, California, in most circumstances, has a pre-printed form that you can do yourself, or we recommend hiring an attorney to make sure the process is done correctly. But if you plan on doing this yourself, basically in section 2, we put in what you will need: the summons, the complaint, the civil case cover sheet, and we strongly recommend the prejudgment claim of right to possession. It's an area of dispute between the property, but essentially that's a form to give to any other tenants in the property that you may not have named in a lawsuit. In filing the lawsuit, you want to name all the tenants that you're aware of. So if it's a husband and wife, you want to name them. But if there's somebody else in the property who claims a right to possession, that prejudgment claim of right to possession will give them notice of the lawsuit, and then when you get a judgment, if you do prevail, you can actually serve it on everybody because you've served that prejudgment right of attachment, right of possession. And so once you've completed the form and once you've finalized that, you have to file it with the court system. The court will then give you back to you and give you a case number, and then you will have to serve the unlawful detainer action. And so on service, we would strongly recommend hiring a third-party person to serve the complaint because they're familiar with the different types of service that are possible and how to actually serve it and file a declaration. So we typically hire a third-party vendor to do that for us. Depending on how it's served, there are various ways, including you can serve by typically personal service and sometimes like substituted service. There's 5 days to respond, but if you do substituted service, there's additional respond. So just look to see what the method of service that was completed based on what your process server tells you. And then if once this complaint is served, then the lawsuit really goes forward. So that's kind of the next step. The way that the lawsuit goes forward is basically 2 major different routes. One is going to be the default route. Effectively, you've served the complaint, assuming that you served with regular service and not substituted service, then they have 5 days to respond. Well, if they don't respond in those 5 days, you can get something known as a default judgment. Effectively, you go to court, you file a document that says, you've properly served the complaint, they didn't respond, and therefore they basically cannot raise a defense. And so that would be the default process. Now, if they do respond and they do answer the complaint and you're moving towards trial, the way the court system works is that because this is an unlawful detainer and because the court system is swamped with a lot of other work, they try to get the parties to resolve the case with something known as a settlement conference. And basically, when you're set for trial, almost every jurisdiction will set you for a settlement conference prior to trial to try to get a resolution. So that's the settlement conference. Depending on which county that you have, the settlement conference may be in front of judge, it may be in front of mediators, and maybe just you two discussing it, outside of the courtroom and just kind of talk to each other. Typically, for example, in San Mateo County, even if the tenant doesn't have an attorney, attorneys are made available to the tenant on the day of the settlement conference and provided only for the limited extent of the settlement conference to try to get the parties to come together. So the attorney will try to explain to the tenants their rights, the likelihood of success of the case, and then try to reach a resolution for both parties. If the settlement conference is not effective, or even prior to the settlement conference, there are some times where, especially on the more litigious cases, or if the tenants represent counsel, that there's a process of discovery and motions. You'll see this most commonly in regular civil cases, but it can come up in the unlawful detainer action. Basically, discovery is allow each side to get information from the others. So you can serve requests for interrogatories, which is basically just questions to the tenant, or the tenant sending you questions saying, please answer this, provide information about what the support of your case is. And then there's other forms too, known as requests for admissions and also requests for production of documents. They, in very, very rare instances, can also seek for a deposition of relevant parties. We almost never see it because it's really pretty expensive and the process is pretty quick, but it is something that a savvy party or someone who's trying to drag out the process and raise the cost can do. The second thing that you'll see is the motions practice. The most common motion you'll see is something known as the motion to quash. And effectively, that's the tenant saying, hey, you've improperly served the complaint, and therefore, or not actually before the court yet. And so they may file that motion. There are also other motions known as a demur, which basically says that even if everything in the complaint is correct, that's still not grounds for a judgment, or a motion for summary judgment, which basically, as it sounds, is to try to get a judgment on the case if there are no facts in dispute. These are all very hyper technical, so if any of these motions come up, we would strongly recommend that you have an attorney and talk to them about it, because this is going to be very fact specific that we can't cover today. But certainly those are issues that may come up, even if rare. And finally, the last step is that if you've gone through the motion process or no motions were filed, the settlement conference was unsuccessful, then you may actually go to trial. And that may be a jury trial or a bench trial, depending on what the parties requested. And so we're going to go over, that was kind of the overview of the actual process. And we want to talk about some of the specifics of what can go wrong and what are the defenses that tenants can raise. And Ashley will take over for that portion.
Yeah, so I'm going to go over some of the most common pitfalls that landlords fall into when they do this. That gives the tenant a lot of ammo to defend against unlawful detainer action. As you'll see here, the most common pitfalls would be, they're branching off of what Henry talked about, and I'm just going to elaborate a little bit more just to describe the effects of not doing these things properly. And those include improper notice, filing suit too early, accepting rent from the tenant, and service issues regarding the unlawful detainer complaint. And while this isn't inclusive of everything, this is probably the most common pitfalls that landlords fall into that we see come into our office every day. So the first one, improper notice, as Henry mentioned, you have to specify the violation and the time to cure for the tenant. Typically it's 3, 30, or 60-day notice, as he described. You really have to be aware of the tenant's rights and give them an applicable amount of time to cure. For instances, you can mess up on this if the tenant's been in the unit for more than a year. You serve them with a 30-day notice instead of a 60-day notice. You're going to run into issues on this, and your whole lawsuit can fail based on that factor alone. And the biggest repercussion for serving improper notice is having to restart the whole process over. So you could be back 2 to 4 months. You would have to reserve them and file again. You can't just refile. Also, you need to wait until the cure period ends to file your lawsuit. So again, that falls back on what Henry said. You have to make sure you give the tenant proper notice, depending on the violation or the reason for notice. So just pay careful attention to that. So make sure you only have to do the process once. And with this pitfall, it's a complete defense for the tenant. And they'd be able to defend the lawsuit just based on this alone. So the next one ties into improper notice and also what Henry's talking about, and that's filing suit too early. A lot of landlords get anxious, or they jump the gun, or they just count the days wrong, and they file too early. We've dealt with this on a couple of occasions, and it really causes headaches for landlords. They get to the settlement conference or even the trial, and the tenant starts counting the days, and you have to start the whole process over. And just, go ahead.
Yeah, so a lot of times what we see is sometimes people will try to post and mail a lot of their notices, and they'll post on one day and mail on a different day.
Right.
And in posting and mailing, which is one of the types of way to serve notices, that it's not effective until the mailing. So for example, if you posted on June 1st, you didn't mail till June 5th, the 3-day time doesn't start ticking until that June 5th date, not on the June 1st date. And sometimes the landlord forgets that, or they didn't notice,
right.
Or they didn't even realize the person who was doing the service failed to put it in the mail. So we've had clients who've come to us having already filed a lawsuit, and we tell them, hey, if this comes up, you're going to lose because you didn't wait the requisite amount of time. The positive side is that, as Ashley will talk about, is that you can cure by refiling. You don't have to redo the notice.
Right, and that's why we encourage you to seek an attorney if you are doing an eviction that is complicated or you have a contentious relationship with the tenant, just because there's so many little details that you can mess up, and we do this every day, and we would help you make sure that you meet those requirements. And so the next pitfall that we want to talk about is accepting rent. So you go and you serve your tenant with a notice, 3, 30, or 60 day, and then say for a 30-day notice, on the 29th day, the tenant goes and pays you rent, and you accept it, that 30-day notice is cured. And so we strongly recommend that once you serve notice, you don't accept rent, except for 3-day notices. You have to allow them to cure if the notice is for non-payment of rent. But for the other reasons, it acts as a waiver, and that notice will be deemed to cure. So we recommend that you don't accept rent, especially for the 30 and 60-day notices where it's a breach or the lease is just ending. Accepting rent is basically communicating to the tenant that they're allowed to stay. So make sure you don't do that. And just like the other one, this is a complete defense to the tenant. If you go ahead and file anyways, they can say that you waived your right to that and the notice is cured. And finally, Henry talked about a little bit the service issues. Depending on how you serve notice or even the unlawful detainer complaint, that affects the amount of time that the tenant has to cure or to respond to the complaint. So like he said, if you post and mail notice and you post on the 1st and you mail on the 3rd, it's not actually effective until you mail it. And so you could be 2 days off on your count, file your lawsuit, and you're premature, and you'd have to restart that process. And so it's just important to note that however you serve, or if you have a third party do it, which we highly recommend because as a party you can't serve the tenant yourself, we recommend that you make sure you're accurate with your dates and you don't file too early.
And to be clear, when we're talking about the service issues in this context, we're talking about the service of the complaint.
Mm-hmm.
So you're not entitled to serve the complaint yourself as a party.
Right.
You are okay to serve the notices by as yourself.
Great, thank you for making that distinction. The next one, we're going to talk about tenant defenses, and while pitfalls do act as defenses for the tenant, these are things that pertain more to the tenant themselves and things that occur to them, usually throughout the lease or going into the lease. Let's go. So these are the most common ones that we see come into our office, and these include an illegal unit, or otherwise known as an unpermitted unit, discrimination, habitability issues, and delay. So we'll talk about these individually. For an illegal unit, it's important to remember as a landlord that when you have a tenant in an unpermitted unit, they have the same rights as a tenant in a legal unit. And this applies to both evicting them when it comes to areas that don't have rent control and that do. So even if the unit is illegal, they still are protected by rent control. And a lot of people overlook that and think that their unit may be immune since it's not actually, doesn't have permits, but that's not the case. You still have to abide by those ordinances. So make sure you know what city you're in. For instance, East Palo Alto or now Mountain View, they still have protections regardless of whether or not you have permits. In some extreme cases, there's been courts that have given the tenant back all rent paid for an illegal unit. Now this is extreme. It's not necessarily the case for all counties, but it's important to be aware of that if you are renting out an illegal unit. Probably more common and makes more sense is the LA Court of Appeal case. The court in that case gave the tenant back rent for any increases in the base rent. It just seemed like maybe they were punishing the landlord for increasing the rent on a unit that didn't have permits. And so that seems more reasonable and it makes more sense when it comes to that. And so for the next one, let's see. Discrimination. So as a landlord, you can't discriminate against the tenant based on family size, gender, race, etc. The list goes on. It's usually the protected classes, protected also by the Constitution. The most common ones we see in our office are familial status and gender. Common situations where this arises is when a family, a married couple move into your unit and then they have a baby, and the landlord, for whatever reason, doesn't want kids in their property, or they don't like the increase in size of the family, and they evict on that reason. You can't evict for that purpose. The tenant will be able to defend the lawsuit based on discrimination. And again, it's up to the tenant to prove that. So you have to be real careful as a landlord. That can't be your reasoning for evicting your tenants, is based on their family size or increase, decrease, and so on. Also gender, although rare, if a landlord charges male tenants more than female tenants, something like that, you're going to lose if you evict the tenant, and then they're also able to come back with that defense. So just be careful when you're drafting leases and also evicting them, the reasoning behind that. You can't base it on those criteria. Next is habitability, and these end up being retaliatory evictions. And so what it comes down to is the landlord cannot evict the tenant if within 6 months of the tenant doing certain things. So if the landlord evicts the tenant within 6 months of them using a legal right, like for instance, we talked about the repair and deduct remedy in prior webinars. There's a hole in the roof. They notify the landlord doesn't do anything, so they use the rent to fix it. And 3 months later, you evict them because they didn't pay rent for that month. That's going to be a retaliatory eviction because they have a legal right to do that. And so if your eviction is based on that, and the courts usually look at a 6-month window, they're going to be able to defend against that eviction. Also, if they make complaints to you about the unit, or if they have the city come out and inspect the unit and they issue citations and you evict them because you're either mad about that or just it's vindictive, you can't evict them for that reason. They have a legal right to do it. So just make sure that the eviction is based on something else that is permitted. And next, in some rare cases, the tenant can delay the eviction when they're filing for bankruptcy. This typically will delay the eviction 1 to 2 months, depending on the complexity. What happens is if you're in the middle of an unlawful detainer action and they file for bankruptcy, the action is stayed temporarily. And also, you have to make sure as a landlord that you don't continue to pursue the eviction at that time. The bankruptcy court can come down pretty hard on you for that. And so you'll just have to wait until the bankruptcy and then you can proceed. It's not really a defense, it's more of a delay. So just be wary of that. So next, Henry is going to talk to you more about the proceedings with evictions.
Yeah, so we talked a little bit at the beginning about what happens, kind of the outline of the lawsuit itself, but I want to go into the specifics. So as we discussed earlier, when you file the lawsuit and you've properly served it, if there is no answer, then you can go down the default route. Essentially what you're saying to the court is that you've served them properly, and so you've now requested a default with the court, and you're saying that you're going to win your case, and you have something known as a prove-up hearing where you say, here's a lease, and if it's failure to pay rent, here's a month that they didn't pay rent, and therefore, because they didn't pay rent, I've properly given notice to the tenant for the 3 days. I've waited for the time for the notice to expire, and all these factors have been met. I'm entitled to judgment. And typically, if there is no if there is no defense on the other side, the defaults are relatively easy because no one's objecting to what you have. You need to provide the evidence saying, here it is. And you will see in that unlawful detainer complaint itself, most of that is already part of the complaint, so you can provide to the court. And so basically you get the entry of default, and then you get a default judgment. And so we'll talk a little bit about what you do with the judgment a little bit later in this, but basically once you get to the judgment, you're at the same stage as if you won at trial. There's some minor differences in terms of the fact that you can set aside depending on if it's a default because of certain issues, but typically in the unlawful detainer, because it moves so quickly, the tenant probably won't move to set aside in time before the actual writ is issued. Now, if the tenant does respond, this is where it gets much more difficult. And this is where we strongly recommend that you talk to an attorney, because likely a tenant's raising some defenses and they've filed an answer. So what you'll see is that with the unlawful detainer action, the tenants will, if they've responded, they will typically respond by filing an answer with the court. Technically, they're supposed to serve you with the answer so you can see what they've said. Not all tenants know that, so you may have to pull it. And I'd just like to note that under California law, unlawful detainer actions are masked, which means that you cannot look up what's happening in your case on the court's website. You actually have to call in and ask for that information, and you have to be a party to the lawsuit. So typically, most counties in the Bay Area, and I think most of California, have an online website where you can look at the court's docket to show, oh, I filed a complaint on this date. I see an answer's been filed. I see these hearings are coming up. But in unlawful detainer actions, because of California law and the attempts to protect privacies and in instances where the landlord doesn't prevail, they've just masked it so it doesn't show up on the public record. Now, once you've gotten the answer, you'll see here are the defenses they've raised, and then you'll want to request a trial. And that's another form that you'll find on the California's Judicial Council website. And you say, basically, I'm ready to set this case for trial because there's been a complaint, there's been an answer, and we want to go for it. Now, when you request that trial, you can request whether you want a jury trial or a bench trial. Typically, as a landlord, we would recommend a bench trial, just because juries are, and in general, juries, it's usually not in the landlord's favor, just because most juries tend to have a bias against landlords. So we request that, but typically you'll see a lot of the tenants ask for a jury trial for obvious reasons. And then as we've talked about, well, now you have this trial set, you still have time to go through discovery and motions. We've already talked about kind of that discovery process, and just be aware that you could ask the tenant if they've raised defenses. So for example, if you've seen them in the answer saying that there's discrimination, then you can ask them about, well, specifically, what are the grounds for the discrimination that they're talking about? Or if they've raised defenses saying, oh, well, no, we actually paid you, or there's some habitability issues, you can go ahead and send that. You can also request that they omit certain facts, like, this contract is accurate, that they didn't pay on this date, and kind of along those grounds. Finally, like I mentioned, there's a motion for summary judgment. Typically, in a regular civil case, that motion takes a very long time. You're required to give 75 days notice in a regular civil action. Obviously, that's unworkable in an unlawful detainer action. So California says that in unlawful detainers, you can do that within 5 days notice. And so that gets heard much faster, because California and most state courts have a policy of resolving unlawful detainers cases within 30 to 60 days. And typically that's what you would normally expect, unless there are some delays that the tenant has or something weird that happened in your case, is to resolve many of your unlawful detainer cases within 30 days, or on the longer part on 60 days. There are exceptions depending on what else is going on. And then, so that's kind of the motion we find to be helpful if your case is very clear, and especially if you sent discovery and they've admitted that they haven't made payments. That could be a way to do it in order to try to resolve the case without having to go to trial. And so that may be something that people want to consider. The typical downside for the motion for summary judgment is that it is expensive to prepare. And also, California does have filing fees for their motions. And some landlords just don't feel that the filing fees are worthwhile to file if they really think that this is going to be a very easy case to prove at trial and they're willing to roll the dice. And so it really kind of depends on your risk tolerance. And so we would suggest that you talk to your attorney to see the viability of these various motions that you may be able to make. And finally, once you have, gone through the motions, gone through the discovery conference, you're going to, if you win, you'll get a judgment. And so that judgment basically comes in two forms. Unlawful detainer actions are very different from other lawsuits because they do provide two different judgments that get resolved that focus on different areas. So in our next slide, basically there's a judgment that's going to be for possession, and the second judgment is going to be for damages if that's what you go for. unlawful detainers in California, the reason why they're special is because the whole point of this is try to get possession back quickly. And so unlawful detainer actions are just about possession. Now, obviously, as part of the possession issue, if they fail to pay rent, the landlord has damages also. But because there's two different issues and the damages can be resolved over a longer period of time and it's not as rushed, California has created this unlawful detainer system for a judgment for getting possession of the property back. So in the unlawful detainer cases, they've allowed it so that you can actually get your possession judgment first and then come back later for your damages portion. And we'll talk a little bit more in a bit about why that's kind of segregated and why you want to wait for your damages. But basically, once you get your judgment, you're going to want to obtain a writ of possession. That's another form. And basically, you give it to the court and say, I've got a judgment for possession of the property. I've obtained this writ. And basically saying that you can give this to the sheriff, and the sheriff will say, yes, I'm entitled to go ahead and enforce this writ to get possession back to you. Just because you've obtained a writ of possession doesn't mean you can do it yourself. You have to go through the legal channels, and that's typically going to be the sheriff. Yet once again, we would strongly advise against self-help because it's not permitted, but go through the legal process. And so depending on the county where you are, the sheriff's department will have different regulations and different kind of methods of doing it and different fees. So each county has their own process. They have typically forms that address this. If you go just do a Google search for whatever county you are, say, San Mateo County Sheriff's Department, unlawful detainers, writ of possession, they typically have a form and they'll request specific information. The most important thing to know about it is that typically what's going to happen is that once they get the writ and all the proper documentation, they will tell the tenant that they're going to go ahead and evict the tenants and that they need to get out. Then that eviction will occur typically about a week later. You'll see in the county, they'll say, do not tell the tenant that, we're coming on this day at this time and you need to be present or one of your agents needs to be present. The reason for this is that once you have the writ, they only do that actual eviction for possession once. So if the tenant is not out of the property, then the sheriff's entitled to get them out. But once they're out of the property, it's your responsibility to change the locks at that point in time so that you maintain possession of the property. So we typically tell our clients, hey, talk to the sheriff. They've set up a time with you at this point in time. Come with your locksmith so that you can change all the locks that the tenants may have keys for. And so, go ahead and get that done, and so that you don't have to go through the process again. Now, once this is all completed, you can go back for damages. A lot of times, landlords don't find it to be worthwhile on just the economic basis because typically if a tenant is not paying rent, which is the most common reason, they probably are judgment proof. Essentially, they don't have any money for you to collect on. But if, in Palo Alto, a lot of tenants do have assets that you can go after, you may want to go ahead and get a judgment for damages. Now, part of the reason why damages are allowed as a second phase is because you don't actually know when the tenant will leave the property. So just because you've gotten the writ of possession, it's not going to get possession back to you immediately. It will take a couple weeks for the sheriff to go ahead and to go through their process to go ahead and get them out. So you're entitled to damages if you've set that up in your complaint properly, saying here's the per diem value of rent for the property, and it took them additional 21 days, and so therefore I'm entitled to that amount of damages. And so you can go ahead and add that to your judgment on the second phase. Now, finally, you've gone through the process, you've gotten the judgment, you've gotten possession of the property back. There's going to be certain times where the tenant, either in disbelief that what was going to happen, or they just leave junk in the property, and they're going to abandon personal property. And so there's certain steps that California provides in handling personal property. You basically have to inventory and store the property in a secure location. Whether that's a storage shed or something else, it's not quite as clear what that secure location is, but you are responsible for doing with that. And then once you've inventoried it, you have to send a notice to the tenant that the property is abandoned and that it's going to be abandoned. And so basically saying, hey, we have 15 plates of yours, we have this couch, we have some sheets, we have some t-shirts or whatever. And you can say, this is what we have. You can pick it up at this point in time, or you can pick it up at this location, or you can contact me. You are also entitled to charge a fee for reasonable fee for the storage cost. So if you put everything into a storage unit and it costs $20 a day for that storage unit, you can say, here's the cost of the storage unit, and in order to get your items, you must pay me X amount, which is increasing every day at the rate of $20 per day because that's the cost. Now, if the tenant doesn't respond to the notice of abandonment, kind of the next step is to determine how much you think the property is worth. Now, in our example of the plates, some clothing, if it's under less than $700, you're basically entitled to dispose of the property. You can kind of do with it whatever you want to do. It's fine because it's less than $700. But if it's more than $700, there's a specific sale of the property that you're required to take place. So, for example, for whatever reason, if you've gotten a writ of possession and the tenant didn't believe you're moving out and they've left like multiple computers, TVs, furniture, all of their items, you can't just destroy it, right? That's not permitted under California law. You are required to go ahead and sell that and basically try to apply the proceeds there. And so that's kind of the process with an abandoned property. And so hopefully this lecture has been helpful. This webinar has been helpful in covering the nuts and bolts of the actual litigation and the actual eviction itself. For anything beforehand, we had a webinar about setting up the contract formation, and we had other about landlord basics, but we really wanted to focus today on the specifics of actually evicting a tenant, and we think we've covered most of that, and we're happy to open this to questions for anybody.
So first question, even if partial rent is accepted, is the notice cured?
Yeah, so if you accept rent, that's the hard part, is if they pay, our general advice is to go ahead and not accept any money, right? Because you don't want to be in a position where there may be any situation where the tenant has a defense saying, oh, I paid them because they told me that if I pay them $800, I was going to pay them another $800 later to cure entirely, they would stop the eviction. And so it's just heavily frowned upon, and I think it may actually be a complete defense at that point in time.
Next question. What do you do with the deposit? Does deposit amount count for a $700 amount for liquidating property?
Sure. So the deposit actually applies regardless of the eviction, or if it's an eviction or if it's a normal move out. You have to apply the deposit in the same way. But one of the reasons why this doesn't come up very often is that because typically if the tenant has moved out and you've had to go through the unlawful detainer process, you are entitled to apply the missed rent to the security deposit. So, for example, they were supposed to pay rent for June, they didn't, but you didn't get them until July. If your security deposit with 1 month's rent, you've already eaten that up entirely. And so, there's no need to return the security deposit at that point in time. And as for the deposit itself, no, it does not apply to your calculations of the $700. The $700 calculation is just about the abandoned personal property at the house. So if you're basically looking at things that are liquidable in terms of like clothing, furniture, TVs, anything you would normally see in someone's household. And
so if any other questions, feel free to ask. We have a few more minutes, so we'd be happy to answer anything that you're not sure about or questions about what we talked about. Question, what types of damages are available?
So the damages that we typically see, and the most common ones, depends in some part also on your lease itself. If you actually have a lease that provides for attorney's fees, which many leases do have for a prevailing party, that's something that you're entitled to put onto your judgment. The other damages that we see most commonly are going to be the per diem rents or the holdover damages. That's relatively clear cut. More often than not, it's just going to be based off, say, if there was a month and a half of rent, then you would just, a month and a half that they've stayed over that they didn't pay for, you're entitled to that back. You're entitled to your costs for enforcing the judgment. So basically, you have the sheriff's fee, and the sheriff's going to charge some amount for the writ, and so you can get that to your judge to attach as to your damages. And then as for breaches of contract, say for example, if you have a lease that goes from January through December, and so and then they fail to pay rent in June, technically you're entitled to your damages for all of the missed rents in the contract. So you'd be entitled to July through December's rent. Now, as a landlord, you do have an obligation to re-rent the property and try to mitigate your damages. So, for example, you have damages for renting the property in July, to re-rent it in June, July. They get out on July 15th, and that's kind of when you've actually got possession back, and you're able to re-rent it on August 1st. Then you would not be able to collect the August 1st through December rent, assuming that the rent amount was the same.
And another thing that as a landlord you might want to note is, say you evict a tenant for not paying rent, he leaves the property and you go in there and it's a complete disaster. Typically you're permitted to get damages beyond ordinary wear and tear, but this isn't included in the unlawful detainer complaint, so you'd actually have to file a separate suit, I believe, which some landlords don't think it's worth it, or the tenant's long gone, you can't collect from them anyways. So it's just something to keep in mind, that sometimes tenants are vindictive and they do things out of spite, and just be aware of what you might walk into.
So the next question we have is, can you evict if the tenant has a pet, and how can landlords discover if they have a pet? So let's be clear. If there is a no pet policy, yes, that is a violation of the lease, and you can evict on those grounds. What we see more commonly now is that a lot of people are saying they have service animals. You cannot evict somebody with a service animal, and there are very specific rules about that, and that actually falls into the discrimination category because it is a protected class. And so California and the federal law actually has a lot of protections for service animals, and service animals under California law is not just a dog. There are various therapy animals that can qualify, and there are a little bit of differences between, I think, a service animal versus a therapy animal. And so if you're looking at a pet and it's just actually a pet, so they decided that, hey, this puppy was super cute, we're going to adopt this puppy because we want it, and you see that, then yes, you could evict on those grounds. You can send them a notice to cure, and they probably won't be able to cure, and then you can terminate and go through the same process we've discussed. And typically, as we've said, in trying to discover the fact that they have a pet, typically the best grounds is to talk to the neighbor, because if they do have, say, a dog, if they're barking all the time, the neighbor would know, or if if they're outside and you just know about it, that would be grounds for it, and you can tell the tenants, hey, you're in violation. And so that's kind of the discovery of it. So that's pretty much our time for today. Thank you guys for all attending. Once again, if you have any questions or specifics, we're more than happy to talk to you. If you have any actual proceedings, or want to retain or talk to an attorney, we're happy to do that also. This is both Ashley and my area of practice, and so if you have any issues about it, this is what we do for a living. And if you have any questions about the prior stuff, our webinar is up there. I think it's been posted in the chat room. It's on our website, or if you shoot us an email, we can send you the link for it. Thank you once again for coming.
Thank you.